This semester we're talking about civil cases in the federal system, but it's good to have at least some general understanding of what place these have in the overall system of litigation and what that overall system of litigation looks like. So we're not going to go in depth here, but just so you have an idea of what the context is in which you're litigating. So one thing to keep in mind is that state courts hear the vast amount of litigation in the United States. The federal courts hear only around 5% of US litigation. And of course, that might lead you to ask, why are we studying the federal rules of civil procedure and not the state rules of civil procedure? And the answer to that is twofold. One is there are 50 states and 2 primary districts, the District of Columbia and Puerto Rico, where state courts hold sway, and that would be a lot to cover in one semester. But the other, possibly more important one, is that the federal courts form their own system. It's a particularly important system because it has a huge amount of influence on the state courts, and it is self-same wherever you go in the United States. So what you're learning here is something you can take with you anywhere you go, and something against which you can measure and understand any state system you happen to be operating in. So let's think about that state court docket for a sec. State courts hear around 100 million cases a year, and of those, around half are traffic-related in one way or another. Of the remaining 50 million, around half are criminal and around half are civil. Of those civil cases, the majority is contract cases. You also have small claims, property, and mental health cases, and probate cases, so wills and estates. Those are mostly only state cases. Torts, which can also appear in federal court, take up around 4.4% of the court docket currently. And then there's a bunch of residual kinds of cases as well. So here's the federal docket. If you look at 2019, you'll see that most of the cases in the federal docket got there because of federal questions. In other words, because they involve some sort of federal statute or a constitutional issue. A little under 100,000 got there because of diversity of citizenship. So those are the 2 primary ways that cases get into federal court. Cases also get into federal court because the US is a defendant. So in administrative law cases, you often have the United States as defendant. And the United States, the federal government, can be a plaintiff. So if the Securities and Exchange Commission is exacting a fine on a violator, they may need to bring them to court in order to achieve that. Here's a rough estimation of the federal court docket. This doesn't quite add up to 100%, but it's around what you want. So note that there's a lot more tort cases here, 25%. Contract cases have fallen to 9%. We've got property as well. And then we have some things that we don't see in the state court docket. We've got a bunch of civil rights cases. Those are federal issues in general. We've got prisoner petitions from the federal courts, labor cases, and some other stuff like IP litigation, which is exclusively in the federal court, Social Security litigation, consumer credit, and some other things. I have the constitutional law challenge to state law up there just to show you that this area of law, which gets a lot of press, takes up such a small slice of the federal court docket that you can't actually see it in the pie here. This is 0.1% or so of the federal docket, although it makes important law. Okay, we've thought about litigation, but what about trial? So in this class, we learn mostly about the stuff that surrounds trials, before trial and some after trial. How many cases actually go to trial? Well, across the federal system, and actually the state system, and both the civil cases and criminal cases, something like 2 to 4% of all cases filed actually go all the way to trial. In other words, almost all cases settle some or are resolved, some other way. They either settle, they're dismissed at the motion to dismiss stage, they are dismissed at the motion for summary judgment stage, or they come out some other way. Almost nothing, in other words, actually goes to trial. But as you'll see in our study this semester, the trial and the jury kind of hang over civil procedure as imaginary institutions that actually guide a lot of decision making. So 60% or so of things that go to trial are torts cases, even though only 4% or so of cases are torts cases. Why is that? Well, because contract cases, a lot of the time, are relatively simple to decide. They're often debtors who owe money to creditors, and there's not a lot of factual contestation about this. In the case of contract cases, those are mostly bench trials. In other words, no jury, just a judge. And the plaintiffs win about 2/3 of the time in those. In tort cases, those occur mostly before a jury, and plaintiffs win around 50% of the time. Okay, having thought a little bit about what kinds of cases appear in court, let's think about how those cases are financed. So most cases in the United States, most civil cases, are litigated under what's called the American rule. The American rule is that each side pays its own litigation costs. So plaintiffs pay their way, defendants pay their way. What are the systemic effects of that? Well, there's going to be quite a few plaintiffs who have a good case and who would likely win on the merits, but they're not going to recover a lot. And if they're not going to recover enough to cover the costs of litigation, it's not really going to be in their interests to litigate. And so this system discourages plaintiffs who have strong but low recovery claims from filing suit. It does, however, allow for impact litigation, where people may pool money or support a lawsuit with the intent of producing legal change for a broad range of people, not just for the person who's litigating. And we actually see impact litigation in our readings today. The case of Fuentes is classic impact litigation with a lawyer representing the plaintiff pro bono, so for free, out of an interest in achieving legal change. There is another way of doing things. We generally call that the English rule, as a contrast to the American rule. So this is the default rule in the United Kingdom. And in that system, the loser pays the winner's fees. So just to think about a little more about the systemic impact of how we distribute the fee payments here, let's think about what the English rule achieves. So in contrast to the American rule, it encourages strong but low recovery lawsuits. If I'm a plaintiff who has, say, a couple of $1,000 claim, that's not going to pay for my lawyer. It's not worth it for me in the American system to file suit in federal court if my recovery is a few $1,000s. In the English system, it does, because if I win, if I have a strong claim, my opponent will pay my fees. And so I don't have to worry about the attorney's fees in that system. At the same time, the English rule makes impact litigation somewhat risky, because if I'm trying to achieve a change in the law and I lose, I then have to pay my adversary's litigation costs. So it increases the costs of impact litigation. The American rule, as we call it, where each litigant pays their own costs, is not the universal rule in American litigation. It is the default rule. So unless there's something else that regulates how costs are spread, each litigant pays their own costs. There are, however, ways of altering that. So statutes, legislation passed by Congress, can involve an attorney fee shifting provision that basically converts our system into the English rule and says, in this kind of litigation, if the plaintiff wins, then the defendant has to pay their litigation costs. Most prevalently, a lot of anti-discrimination statutes are fee shifting. So if I sue under Title VII, which prohibits sex and race discrimination, or the Americans with Disabilities Act, which prohibits discrimination on the basis of disability, and I win, then my defendant has to pay my litigation costs. And the idea of that is every lawsuit by somebody vindicating a public good statute, like an anti-discrimination statute, is basically a service done by that private party on behalf of the public interest in decreasing discrimination in our system. Another way of thinking of that is Congress can pass statutes and then outsource the enforcement of those statutes onto private parties, rather than having some sort of regulatory system that goes around and determines whether, for instance, employers are discriminating against their employees. So this is a fee-shifting statute is a little bit of an encouragement for people to litigate in situations where Congress has determined that it's in the public interest for litigation to happen. Okay, so with all that fee discussion, the next question I'm sure that's burning on your mind is, so how do I make money? And there's actually a number of ways that lawyers structure their revenue situations. Let's just walk through the most common ones here. So some people get paid by an hourly fee. And if you think about the incentives and limits of the hourly fee, well, the hourly fee can be prohibitive for some litigants to pay. But it's nice for the attorney to have some predictability about how much they're going to get paid. At the same time, it might have a bit of a perverse incentive sometimes for attorneys to extend how much they spend, how much time they spend on a particular matter to increase their hourly fee. So another way of dealing with the fee question is to have a flat rate per case. In this situation, doesn't matter how long or how short you spend on it, you get the same amount. These are generally used for predictable, low volatility areas. So a really basic real estate contract in New York, you need a lawyer to look it over. Very predictable, not a lot of variation, not a lot of danger. So you can charge a flat rate and be fairly certain that you'll still be making money. Another way that lawyers get paid is through insurance. So if my, say, driver's insurance has liability insurance, then the insurer will pay the lawyer if I need to be involved in litigation. And finally, another way is what's called the contingent fee. So it's an agreement between an attorney and a litigant, such that the attorney gets some percentage of whatever the litigant recovers. So either in settlement or in the final recovery, but the attorney gets nothing if the litigant doesn't recover. So this is a way of allowing plaintiffs who otherwise could not afford an attorney, say with an hourly fee, but have a strong and high value case, to get representation by basically promising the attorney some of the recovery ahead of time.